good evening, good afternoon, good morning, good late at night, whenever it is that you might be watching this video in the comfort of your own home. My name is Eric McLennan. I'm an attorney with Orton Cavanaugh and Holmes, and this video is designed to be a short discussion with regard to contracts, and specifically certain provisions or clauses in your contracts that you might want to be sure that you have if you're currently negotiating or about to sign contracts for the upcoming season. This is a unique environment and circumstance that we're working under, and so I wanted to reach out to you and let you know what to look for in particular with regard to this time that we're living in and the contracts that you might be getting ready to enter into. First, a disclaimer. This is an informational video. It's not intended to be specific legal advice for any one association. It contains recommendations for best practices. It's not intended to be specific legal advice, but if you do have specific legal questions or require legal assistance, our office is open. Please reach out to us. With that being said, let's jump right in. Here's a scenario for you. Happy Acres HOA has a pool. Typically around this time of year, the association will contract with a pool company to do everything needed to open the pool, and the opening is Memorial Day. The pool company has set the association its contract for review, and the contract is a little bit sparse, but it's for a significant amount of money, around $50,000, let's say. The association is worried that the current stay-at-home order or other governmental directives may make it impossible to open the pool on Memorial Day, or even at all for the coming season. The association doesn't want to be stuck in this pool contract. You don't want to be liable for breaching the contract if you have to stop the work due to circumstances that you can't control. How do you make sure this doesn't become a problem? How do you make sure you can get out of the contract without penalty or loss? There are a few specific provisions that you'll want to make sure are included in the contract before you sign it. Let's talk about those. First is an amendment clause. This is simply a clause which allows the parties, after the contract is signed, to agree to amend the terms of the contract. We always recommend that such a clause require amendments to be in writing and signed by the parties. This type of clause would allow the parties to negotiate a later starting date, perhaps, or to agree that the compensations should be reduced if the swimming season is shorter than originally anticipated. An amendment clause is always recommended in your contracts, regardless of whether or not it is during this odd circumstance that we're under right now. But what if the contractor is not cooperative in negotiating an amendment? Well, next you'll want a good termination clause. You want a clause that allows the association to terminate the contract under certain circumstances or conditions. Best of all is a termination for convenience clause. This allows the association to terminate at any time for any reason upon giving a certain amount of written notice to the contractor. Typically, such a clause will require you to pay the contractor for any work that has actually been performed up until the termination date, and that's only fair. Or you could have a termination for default clause. This is a little more complicated because you typically have to give the contractor notice of what they've done wrong and give an opportunity for them to cure their default prior to termination. This type of termination clause is probably not as useful in this scenario because the contractor hasn't necessarily done anything wrong, but has simply been prohibited from performing due to outside circumstances beyond their control. In this context, this specific context, you'll want to be careful that the contract doesn't allow the contractor to hold the association in default because circumstances won't let you to proceed with opening the pool. That's something to look for when you're reviewing these contracts. That brings us to the concept of force majeure. which is a French word that translates as superior force. Legally speaking, it is an event or effect that can be neither anticipated nor controlled. The inability to open the pool due to a pandemic and governmental orders to socially distance certainly falls within that category. The idea in this scenario is to make sure that you have a force majeure clause in the contract that the association would be able to invoke to excuse its requirement to perform. In other words, the association cannot be held liable for stopping the contractor from doing the work due to this force majeure that has made it impossible to achieve the thing that the contract actually contemplates. A force majeure clause is certainly recommended in any contract that you're reviewing, negotiating, or anticipating signing in the near future. Keep in mind, when you negotiate a contract with a contractor or vendor, it's just that, a negotiation. The vendor or the contractor may not agree to all of the proposed terms that you're trying to add to the contract. Nonetheless, we do recommend that you try as hard as you can to protect the association and its members and to get these provisions that protect the association into the contracts. If they're intractable, you might want to consider going to another vendor or contractor and trying to negotiate a contract with them instead. I hope that this video has been helpful to you. If you should have any questions, feel free to contact an attorney at Orton, Cavanaugh and Holmes. We would be happy to discuss any specific situations with you or to review any contracts that need reviewing. Stay safe out there.